We're going to start with this.
I want to bring us all into the fold together so that we can fight this.
Actor Jason Patric has taken his custody fight for his 4-year-old son Gus to the next level with Stand Up for Gus. Hey! Calling a father just a sperm donor is an insult, but it may also be the legal fate of certain unmarried dads. Actor Jason Patric says he's one of them.
Actor Jason Patric has scored a big victory in his legal fight concerning his son. Now, a California appeals court ruled that he should be recognized as the 4-year-old boy's dad.
I was a dad to my son, and now I've disappeared from his life. So this winning the appeal doesn't give me my son back. It gives me the ability to go into court and prove that I've always been the father, which was everything I've done is for the love of my son.
Well, strong words there, pure abduction. The lawyer for the boy's mother, meanwhile, released this statement to People magazine. I want to read to you. We respectfully disagree with the Court of Appeal. We are exploring our options and should make a decision shortly. The best interest of the child continues to be our goal. His well-being, not publicity, will dictate how we proceed. Let's talk to criminal defense attorney Philip Holloway about this. In your opinion, first and foremost, and thank you for being here,
My
Phil.
pleasure.
Did the judge get it right, the appeal judge?
The appeals court did get it right. You know, universally, almost throughout the United States, the legal standard that courts apply is what is in the best interest of the child. And I think that the Court of Appeals has come to the correct conclusion that it is in the best interest of this child for his father, his natural biological father, to have an opportunity to be in court to prove that he is a dad. And if a picture speaks 1,000 words, we just saw the photographs of him being a father, loving the child, doing the things that dads do. And so I think the judge absolutely got it right.
So he signed all these papers intending to be a father, he said, when they went through in vitro. Would he be dealing with this if he weren't in California, or is this strictly state by state?
Well, this is I think it's something that's unique to California, at least in the way this specific statute is written. The key question here is whether there's a binding donor-only agreement. If there were, it would be one thing. But even if there were, that agreement can be said to have been abandoned because clearly the mother has allowed him to be a father, has held him out as the father, has allowed him to participate in the child's life. So their conduct subsequent to the child's birth proves that if there was an agreement, it was modified by their conduct.
Now, there are reports that his name allegedly is not on the birth certificate. That's what she says. If that is the case, is that damaging to him at all?
Well, it doesn't help him, but it's not conclusive proof of anything either. You've got to look at the totality of the circumstances. I don't think there's really any question that the child biologically is his. They tried several times to have a child naturally, but they were unable to do so, so they turned to in vitro. There's no real question that he is the biological father, and so his absence, the absence of his name from the birth certificate is not really going to be anything that's going to be fatal to his case.
Okay. Philip, thank you so much for being with us. We appreciate it. Philip Holloway there.